Thank you for watching this video. Please help us keep the show alive by liking and sharing this video and by subscribing to the show and making sure the notification button is switched on. For those of you who can help a little bit more, there's a Patreon link down below where you can contribute whatever you can. Every little does help, and all the money will go directly back into the show. You can also keep up with our latest content on Instagram at The No Show Pod, as you can see on the screen. As you know, The No Show is an initiative designed to make academic research accessible to everyone. So do contribute to the conversation, leave some questions, have a discussion, and I'll make sure I get back to everyone. So, John, thank you very much for joining us on The No Show. I'm really pleased to have you. Before we get into sort of the nitty-gritty details of your forthcoming book or your most recent book, would you sort of introduce yourself to my audience and a bit of a background about your work?
Yes, I'm a social anthropologist at the School of Oriental and African Studies. I have been doing research on Africa for 35 years. And over the last 15 to 20 years, I've increasingly been looking at the courts. So I've published 2 books and many articles on different aspects of asylum. I've spent a great deal of time doing research in different asylum courts, in the Court of Appeal, and in the Royal Courts of Justice, and working with lawyers as an expert witness myself in asylum cases, but also looking at how lawyers litigate cases, a range of different cases. The current book is based on about 9 months of anthropological fieldwork in 13 different magistrates courts across London, covering the vast majority of London, but not all of it, right? And in that research, I collected material on 238 initial or remand criminal hearings and 23 criminal trials. And I've broken that down both into ethnographic accounts of what people actually say, which I then use. And also I've broken it down into a quantitative database, which looks at 58 different elements of each case. And the book is based on an analysis both of what is said in the courts and a statistical analysis of the kind of cases which have occurred. So the book is actually broken up into different chapters which look at different types of cases. So there's an introduction. There's a chapter which introduces all the legal actors in the book, from the police to the Crown Prosecution Service to judges, magistrates, probation service, the defendants, and anybody else who enters the courts and has any kind of a role, right? In addition, I use the statistical material to look at public order offenses, domestic violence offenses, issues of theft and ordinary crime, motoring offenses, fraud, and drug offenses. Mm-hmm. And I look at how this criminal justice system handles all these different types of crimes.
So can I ask, what was the impetus that sort of pushed you towards looking at magistrates' courts?
Well, 2, really. The first is there's been no anthropological research on these kinds of courts. In fact, there's been no recent research on them at all since the 1980s, early 1990s. So it was more than time for somebody to have a look at these. But the second is I just find courts fascinating because you hear key aspects of an individual's life in front of you, and the courts are determining what's going to happen to them, whether they'll be granted asylum or refused asylum, whether they'll be found guilty of a crime or not. So everything is there in front of you. Everything is spoken verbally, and it provides a perfect opportunity for an anthropologist like me to be able to understand the quality of justice.
Mm-hmm. And I mean, as you mentioned before the recording, the findings of the researcher, which the 9-month research, were outrageous in a number of cases, and I think you mentioned the word shocking. Do you think, based on what you've seen in this research and all these cases that you've sat through, do you think that there is an argument that the courts are racist?
I'm sure if you ask the individuals there, they would say no. But if you look at how cases are processed through the court, with very little attention to the vulnerability of the clients, then I think the key answer is the implications are highly racist. Yes. What we haven't talked about as well is people who are vulnerable in other ways than simply in terms of their ethnicity or their race. About 20% of the cases which I saw were individuals who were mentally unwell. It was very clear they were mentally unwell. Now, according to the law, these individuals should be diverted out of the court to other institutions to be dealt with. This is not happening in the London area, okay? And in a number of these cases, people are found guilty even though they're absent from the court or in a mental health institution somewhere. They're still found guilty and charged, right? So there's a whole number of very serious issues arising here about the quality of legal representation, about the processing of Black and ethnic minority individuals, and the lack of attention to the vulnerability of people with mental health issues, which come up again and again throughout the cases.
It's very interesting that you sort of point to the vulnerabilities that a lot of people might be encountering besides race, which sort of begs the question is, what measures are the courts taking in ensuring that there is, there is justice, justice is being handled in a way that is inclusive, so that there's many cases and loads of reports that we see on the news and we see on all these sort of academic articles about there being an imbalance or disproportionate favorability towards white males or white people. But then if there's a plethora of issues like mental health and that sort of stuff, are the courts bearing that in mind, or is it just a complete, are they completely oblivious to it?
I say largely they're oblivious to it, but this is why the subtitle of the book is about. I called it "Precarity and Justice in London's Magistrates' Courts." A large number, and for different reasons, a large number of defendants for different reasons live highly precarious lives. They're unemployed. They have unstable incomes. They're living on state benefits, and we know that benefits are constantly being withdrawn or cut in different ways, right? Many people are living on the street. They're homeless. And it's these people who are brought in a kind of a conveyor belt into the magistrates' courts and who are found guilty and convicted. And the majority are convicted for fairly short terms of sentences. Now, that means if they have a mental health problem or a drug addiction problem or another vulnerability that needs to be treated, in a short term in prison, they don't get access to the treatment. It's only long-term prisoners that get some kind of access to mental health care, all right? So what that means in the long term is these people are released on the street, they come back and they reoffend again, or they're picked up by the police again, all right? So there's just this conveyor belt going around and around and around, processing people who are politically illiterate, legally illiterate, who are maybe even functionally illiterate because of the poor quality of access to education. We think of all the young Black boys who are being excluded from school and entering county lines or gangs in London. I didn't see these boys because I didn't have access to the juvenile courts. I only had access to the adult courts, right? But it begins there, doesn't it? And you get this recycling of individuals through the criminal justice system, and that's what I was seeing. I saw white defendants who had upwards of 50 convictions for theft. Some of them looked forward to going to prison. I saw defendants who owed the courts tens of thousands of pounds in unpaid fines. I saw individuals being arrested for alleged attempts at theft, but who were convicted for being outside their zone, their ASBO area, where they're not supposed to trespass. And yet the zone was constructed in such a way as they couldn't access the city center to even sign on with the courts.
This,
So there's a total indifference in a sense.
I mean, it does appear that way, and I mean, you pointed to some really important issues in the book, and issues that I am certain that affect a lot of our listeners. One of the issues that really sort of is kind of I don't know, is visceral for somebody like me because of the fact that I grew up in a certain way in a certain environment where it was predominantly Baying people, and our experience and knowledge of how the legal system works was non-existent. And you mentioned that one of the things you pointed to was this excessive use of legal language in the courts that is not accessible for many people. What's the purpose of that? If the defendant can't understand what is being said about him and concerning him, is it just something that is designed to be exclusive?
Well, it has that function. It's the way the courts have always functioned, as my understanding, right? Indeed, the last book written by a sociologist on the courts in London, on Uxbridge courts, Pat Carlin, talked about the function of the language to make sure that you didn't understand what the charge was. But if you look at it, what happens is the police use the statutes to charge an individual, whatever the offense is. So there's a particular statute that they charge you with. They create a case file on you. The case file is sent to the Crown Prosecution Service. The Crown Prosecution, the CPS reviews the evidence in the file, supposedly reviews that evidence to see if there's really a case, and then it's sent to the magistrates' courts, where the arraignment of the individual is on Section 4 offense of the Section 4 of the public order offense, which has to do with, for example, the way you speak to a police officer. Okay, that's not the actual term, but there's a particular term in the Section 4 offense, which is about speech. Okay, and that's throughout the process. You're arraigned under Section 4 of the Public Order Act. Now, there is one type of limited defense against that, right? That particular Section 4 offense, unless you know it and can cite it and have good evidence. That is, for example, that in this case, the issue was that you were using offensive language in a public area, and the defense is that you were using it in your own house. And you were not aware that other people were listening or aware that you were speaking. Okay, that's the only defense. Okay, so if you were out in public somewhere and you had a placard which was racist, for example, or was deemed offensive, or you were stopped by the police somewhere, and there are cases which I cite in the book of individuals being rousted by the police, right, and searched. And one man said, it's in the public record, one man said, I don't know what the fuck you're searching me for, right? And he was charged under a Section 4 offense of offensive language to the police, right? And they came back to him later. They were looking for marijuana. They didn't find any. They came back to him, and later he said, I told you wouldn't fucking find anything. Into court. Okay? So there's these issues about the use of language and your right to defend yourself. And they're but when this offense is cited in court, they cite the language from the text in the statute. Mm-hmm. And unless you are legally trained, you have no idea. Another example is domestic violence. There is no single domestic violence statute, but there is something like 30 plus different laws which set out different kinds of offenses under domestic violence. At the rate that the case is being heard in the court, it is often not stated which offense you're being charged with under the domestic violence. So you don't know, and your lawyer may not know, what your defense is against that charge. because it's going so rapidly. Okay. So the problem is that the proceedings are dominated by statute or legal language. It's very convoluted. It's very complex, right? And unless you have legal training, you haven't a clue what's going on.
And I think that obviously, so let me give you a scenario. So suppose that we have a white middle class male in his, say, mid-30s who is of good means, can afford a good lawyer, and compare that to somebody who is, let's say, the same age, but has some kind of vulnerability, whether it's mental health or whether they're from an ethnic minority or low income, and is generally low income, and they're charged with the exact same offense. In both cases, like the likelihood that let's say one would be charged, or let's say both of them would be found guilty of the same thing. How likely is that from the experience that you had in courts?
Well, it's difficult to give you a direct answer to that because you never see two people of contrasting cases like that. But but I did see a number of different Black people charged with drug offenses, for example, men and women, right? And Asians on drunk driving, right? And the outcome is surprisingly different in different cases. And in different courts. Sometimes magistrates bend over backwards to be really fair if they think somebody is particularly vulnerable. Most of the time, they're processed very rapidly. So you don't even get a chance to speak in the remand hearings. You make a plea. Are you pleading guilty or not guilty? That's it. That's all you say. The rest is up to your lawyer. In many cases, the lawyers only assist the court by providing further background information on you, the defendant, right? Or they offer what is called mitigation.
Mm-hmm.
So, for example, I saw individuals, one young Black man who was charged with failing to obtain a ticket on public transport, a common offense. I sometimes saw court lists with 30 or 40 people at one time on one court list who were charged with the same offense. Okay, but in this particular individual, the duty solicitor said, "Your Honor, this is an upright young man. Okay, he really hopes to make a career in design, and he wants to be able to go to the United States to further his career. He can't do that if he gets a criminal offense." And the magistrates listened to that, and they really fined him. They didn't make him serve time.
Okay.
So there's a huge variability across that. Other cases, I saw a case of in the same court, I think, of two young Black men who were arrested via sus and found to be in possession of some level of drug. Mm-hmm. Okay, and clearly the seriousness depends on what kind of drugs you're found with. Okay, but in one case they pleaded guilty. In the other case, the lawyer was very good and said, actually, this could have been dealt with out of court by a fine by the police. And he asked the Crown to reconsider the case, and they sent it back to the Crown to consider dropping the prosecution and dealing with it via an out-of-court means. So there's huge variability across even the same court and how they handle similar offenses. And that isn't what should be happening.
I mean, that's really interesting because it says that providing you have the means and the sort of awareness to find yourself a really shrewd and sharp lawyer, you're not really going to get a fair hearing in a magistrate's court.
I don't know about the shrewd and sharp. The key difference is whether you can afford to privately instruct a lawyer, right? Your own person, somebody from a law firm, or whether you're dependent on public legal aid. And then within that second category, it also depends on how vigorous that public defender will actually be on your behalf. Sometimes they offer no defense. They only provide information to the court about your background. Sometimes they're extremely vigorous. And if they are vigorous in defending you and in offering mitigation, then the sentence will differ.
So it's one of those things that have been going on for God knows however many years, and it seems like there's always I guess it's not a sexy enough campaign for it to be something that the public would demand some kind of reform in. So how do you change that? How do you I mean, from your opinion, do you think that it's possible to change these proceedings to make them fairer?
Yes, I do. And there are examples in the UK about this already. There's something which was imported from the United States about a decade ago called a therapeutic court. And these in the United States, they dealt with families individuals who had children, but the adults were strongly dependent on narcotics of some kind. And they were likely to have their children taken away from them. And what these therapeutic courts did is they worked long term with the defendant to help them resolve their drug problems in order to allow them to keep their family together. And what they did is they have a lot of support through probation, through counseling, through follow-up drug counseling and things like that, to try to get these individuals to get control of their lives. And the hearings are not dominated by legal language. They're face-to-face. The judges aren't even in their gowns. They're held informally. There's a discussion so that the defendant knows what's happening. They can understand what's happening and what the consequences of not turning their lives around will be for their children. And these courts were initially brought in by about a decade ago. They started up, but have not received continued funding from the Ministry of Justice. There are one or two courts, as I understand, still operating this way, therapeutic courts. But what they do is they provide us with a different way of doing this. So one thing is, you could easily drop the legal language. The second thing is, the CPS could have more oversight over the cases to make sure that there's actually a good reason to prosecute a case and or to divert vulnerable individuals. The third issue is slow down the proceedings. You don't have, the reason why most of the defendants are in the dock relates to the 1970s with the IRA trials, right? There was a serious concern at that time that IRA terrorists in the dock would commit violence, or violence would be committed against the judiciary. They've maintained individuals in the dock from that time. 99.9% of defendants are not about to jump out of the dock and attack a judge or their lawyer. Bring them out of the dock, let them participate in their hearings, let them actually have some voice. That would, I think, make a significant difference.
And I think this is really interesting. That you present these ideas, and I think these ideas are all spot on. I don't know if you've sort of elaborated on it much in the book, but would you sort of mention briefly why is it that these you mentioned the word conveyor belt? Why is it a conveyor belt? Why is it so processed so quickly? Is it because of the huge amount of backlog that the court faces?
It isn't now, no. It's a historical fact, and it has to do with in the 18th and 19th century, every individual charged with a crime was allowed a jury trial, not a quick trial before a magistrate. But as the equivalent of the Ministry of Justice operated and the government operated and they came forward, there were more and more people coming up in the courts. So a jury trial was seen to have a very high financial cost. So they began to introduce a means of filtering out the cases. And the idea was that serious cases would go to the Crown Courts for a jury trial, and minor cases could be heard by magistrates. But the problem was, what is the dividing line between serious and minor? So in the 19th century, for example, it was thefts of £5 or more went to the Crown Court for trial. £5 or less, close the door, please. Right, £5 or less went to a magistrate's court. But what's the difference between £4.99 and £5? Right, so this turned out to be a highly arbitrary definition. So what they've done is they've moved the goalposts back. So today, far fewer people have the right of a jury trial. That's only for serious or either or crimes. Murder, homicide, substantial drug cases, large-scale fraud cases, certain kinds of other minor crimes, which certain types of GBH, for example, or assault with knives or acid attacks, right? When it comes up in the initial magistrate's court, the Crown prosecution says to the judge, I think this case should be sent to the Crown Court for trial. But if the defendant also has a right to say whether he wishes to be heard by the magistrates or by the Crown Court. The decision there is also influenced by the fact that they know that if they go to the Crown Court and have a jury trial and are found guilty, the sentence will be far more harsh. So most individuals elect for a magistrate's trial. Right? So there's all these filtering going on, which leads to very high caseloads in the magistrate's courts. But they're not busy all the time, these courts. There are at least 1 to 1.5 to 2 days a week in every court when there are no hearings scheduled. So the magistrate courts are not overburdened. What's happening is that there are budget cuts being made through the Ministry of Justice, and these are not new; these have been ongoing. So so there are fewer magistrates sitting. There are fewer magistrates' courts. Somewhere between 1/3 and 1/2 of all magistrates' courts in the UK have been closed and sold off over the last 7 years. And what's happening is that the Ministry of Justice is moving on to an online form of pleading for all kinds of minor offenses. It won't be for murder or acid attacks. It'll be for traffic offenses and things like that, where you plead online and then take the fine. Now, my own view of this is I think this is wrong because, as in the past, I think the law, if it's properly administered, has something to say to all of us. It has something to say about what is proper behavior, about individual accountability, all right? And the more that these cases are hidden away or go online, then we're a more diverse nation. I myself am an immigrant from the United States. Okay, so the less we understand about the law, the more likely we are to find ourselves in front of it. So I think the courts can play an educated role, or they should be trying to play that role. And that's not what's happening.
I mean, just on that note, do you think that there's that would be beneficial in general to sort of provide that legal education from a young age at school, for instance, within
Absolutely. Absolutely. And it's something I look at in the chapter on domestic violence, because one of the things that I found there was that people of all ages, all genders, all ethnicities were up in the court. Grandparents attacking grandchildren, children attacking parents, male partners attacking male partners, okay? And this begins by understanding, this should begin by having basic legal education at secondary school level. Know your rights, but also have a clear understanding of your responsibilities as an individual of society, right? And I think that should clearly be part of our public educational system.
And as a sort of social anthropologist, where would you like to sort of take your findings from this work, or take take your research beyond this work on magistrates courts?
Well, I've attempted to submit it to two recent inquiries. You probably heard about 10 days ago, 2 weeks ago, there was a joint committee in the House which looked at the impact of law on Black lives, and they reported. Now, I didn't know that they were actually soliciting information before that time, but I sent a short paper and a link to my book to there saying I would send the book to them. And they've replied fairly positively, saying they're waiting to hear what the government has to say. But the other one is the recently announced Boris Johnson initiative to look at ethnicity and health and law. I can't remember the name of the commission, but there's an Asian lawyer who's been appointed at the head of this commission. And I've also submitted my book to them to see if it would enrich the picture that they will be looking at. But I have yet to hear back.
I mean, I most definitely, as somebody who is all too familiar with this world of, having to enter this court system or this legal system and not understand the dynamics between the legal players and the relationships. And one of the things that having been in a court myself, one of the first things that shocked me, and I've been in courts many times for many different reasons and observing and that sort of stuff, is one of the things that shocks me is this familiarity and friendship between sort of lawyers and the CPS, or lawyers and judges, and this sort of dynamic. And as an outsider, if you don't understand this world and you don't understand sort of how to prepare for it, I think you'd be drowned by it. So I think the work that you've done is fundamental in sort of shedding light on what the court systems truly look like. Because to an outsider, it's just, the law's going to deal with them. But how does the law actually deal with people? And I think the work that you've done is extremely important for young people to be familiar with. It's extremely important for people who have vulnerabilities, or people who work with people that have vulnerabilities, have to look at this kind of work and to sort of better understand how the law works. So on that end, I think you've done a remarkable job with opening up our eyes to what the magistrates courts look like. And I wonder, would you, what stopped you from going into sort of Crown courts as well?
It was the lack of time and no resources. I've done this off my own back, really. The previous two books I did were based on funded research from the research councils. This I was simply interested in doing, and I paid for it myself.
Oh, that's
my
amazing.
Own time.
That is really amazing, and honestly, that it's a fantastic initiative that you've taken. Do you feel like this kind of work just doesn't attract support?
Yes. I think there's a number of issues which surround this. One is there's very little anthropology in the UK which looks at the law. There are only 2 or 3 or 4 individuals who do this, and mostly it's around international issues. And myself included, most of my work was on asylum, but not on criminal law or other things prior to this book. The second is that the UK higher education institutions are really locked up now. They've got serious funding problems. There's going to be problems with the viability of some of the smaller institutions in the long term. And now we've got the impact of COVID-19, which means that none of my former colleagues have time to work, to research. They're involved in huge amounts of face-to-face online learning. So it's very unlikely that there'll be much new research on this in the future.
Which is, it's extremely disappointing. However, Fingers crossed we can sort of get this work out there in front of the right people and hopefully, you know, attract the right people towards it. But in any case, I think it's a remarkable piece of work. Moving forward, I mean, in terms of advice, if there's sort of up and coming social anthropologists or people studying the law, what kind of advice would you give them if they want to look at this world?
The key thing is that the courts are public institutions, and every citizen, every individual has the right to go in and watch proceedings. And if you watch a number of different cases, you will gradually understand what's happening there, or you will gradually come to understand the difficulties which face defendants as they're locked in the dock. The courts are also physically arranged in such a way as to enhance the power of the magistrates or the judge, right? So the platform on which the judge sits is the highest point. There are enclosed plexiglass docks, which most defendants are sat in and locked in. And then there's no one in the public gallery. And 90+% of the cases I saw, not even family members of the defendants were present. So these are very private proceedings. And as I found out and was reported to me by research conducted in the 1980s, the magistrates also are unclear why strangers come in to sit in and listen on the cases. So they often query you, who are you? And because of my age and my looks, and I used to come in a tie and jacket, they assumed I was another magistrate or a government official, and I disabused them of that, right? Occasionally in Westminster Magistrates Courts, I used to teach a course on the anthropology of law, and I brought my master's students into Westminster Magistrates Courts. And you come in with 8 or 9 students and sit in the gallery, and all of a sudden, right, there's a public presence, and there's this unease. So they all of a sudden they ask who you are. So I told them who we were, that we were anthropologists observing them, and they laughed. They laughed, which I thought was hilarious, right? As if we would have nothing to say about the nature of justice. And my students picked this up very quickly. So one thing might be for academics to teach their students by taking them into the courts to see how life really works. Okay? What happens to homeless people when they're arrested? What happens to people arrested for drug offenses? And you go in and you can get enough through observation to write your student essay, right? Through repeated observations, you get enough, like I have, for a chapter or an article, right? It's there before you, but you've got to understand the language. That's the key. And you've got to look at the nature of interaction in the court. Who speaks, who doesn't, the turn taking which occurs, right? And it will become apparent to you very quickly after a number of these short hearings, right? And then you get to the real sense of the conveyor belt nature of it. So it's there for you to see if you take the time to do it.
Where can people find you online?
The Department of Anthropology at the School of Oriental and African Studies. If they look at the retired staff section.
And where can people access this book?
It's published by Cambridge Scholars Publications.
All right.
It came out last month.
All right. We'll link both the book and your profile and so on the show so people can get instant access to it. John, I really appreciate you taking the time to join us on the No Show. So thank you so much for being here.
You're most welcome. I've enjoyed it.
Thank you for watching this video. Please help us keep the show alive by liking and sharing this video, and by subscribing to the show and making sure the notification button is switched on. For those of you who can help a little bit more, there's a Patreon link down below where you can contribute whatever you can. Every little does help, and all the money will go directly back into the show. You can also keep up with our latest content on Instagram at The No Show Pod, as you can see on the screen. As you know, The No Show is an initiative designed to make academic research accessible to everyone. So do contribute to the conversation, leave some questions, have a discussion, and I'll make sure I get back to everyone.